Hey everyone, welcome to this rapid-fire revision explainer. I'm your mentor, and today we're locking down all India rank level clarity on sections 123 to 127 of the Companies Act 2013. Look, if you're prepping for your CA exams, you already know that dividend provisions are an absolute goldmine for examiners. They literally love testing the tricky timelines, the weird exceptions, and of course, those strict penalties. So grab your notes, sit up straight, and let's just conquer this topic together. Okay, let's dive right in.
All right, here's our roadmap for this revision marathon. We'll be looking at declaring the dividend, dealing with the inadequacy of profits, unpaid dividends in the IEPF, shares in abeyance, and finally, the penalties for non-payment.
Starting off with Section 1, declaring the dividend, and Section 123 basics.
Okay, concept introduction time. Under Section 2, subsection 35, the term dividend legally includes any interim dividend. Simply put, it's just the distribution of profits to members, and that means both equity and preference shareholders. You know, why does this even exist? Well, when investors risk their hard-earned capital, they obviously expect a return on that investment, right? This is simply the company's way of rewarding that trust.
Now, I need you to pay super close attention to the core difference between interim and final dividends, because the examiner absolutely loves asking questions from this area. An interim dividend is announced by the board of directors between two annual general meetings, way before the final accounts are ready. A final dividend, on the other hand, is recommended by the board, sure, but it's actually declared by the shareholders at the AGM. And here is a massive exam trap that students fall into all the time. An interim dividend can actually be revoked if you get the consent of all the shareholders. But a final dividend? No way. Once it's declared at the AGM, it creates a legally binding debt against the company, and it cannot be revoked under any circumstances. Seriously, lock that difference in your memory right now.
So where does the actual money for this come from? Well, you can use current financial year profits, previous year's undistributed profits, or a mix of both, but always after providing for Schedule 2 depreciation. You can also use money provided by the central or state government if they gave a guarantee. But guys, students mess this next part up constantly, so listen closely. You can never ever pay dividends out of unrealized gains, notional gains, or the revaluation of assets. Let's think about a practical business example. Say your company's factory building suddenly doubles in market value. That's great, but it's just a paper profit. You haven't sold the building, so you don't actually have that cash in hand. The law says, nope, you cannot declare a dividend based on that mere revaluation. It absolutely must be out of true, realized free reserves.
Moving on to Section 2, inadequacy of profits and the crucial Rule 3 test.
Okay, this is a 3-star, high-probability practical question area. What happens when a company wants to declare a dividend, but their current year profits are inadequate? Enter Rule 3. You really need to memorize this mathematical flow. Think of it like a strict 3-step security check. Step 1, the dividend rate cannot exceed the average of the immediately preceding 3 years. Now, if you didn't pay any dividend in those 3 years, you just skip this step. Step 2, you can't just empty the bank. The maximum amount you can draw from reserves is 10% of your paid-up share capital plus free reserves. And, super important, before you pay a single rupee out, you got to set off any current year losses. Finally, Step 3, after withdrawing this money, your remaining free reserves must still be at least 15% of your paid-up share capital. Why so strict? Well, the examiner's perspective is simple. The law wants to ensure you aren't bankrupting the company just to force a dividend payout. Always remember the order. Average rate check first, then maximum 10% withdrawal, leaving a minimum 15% balance.
Let's talk about key restrictions. Section 8 companies, our nonprofit organizations, are strictly prohibited from declaring dividends, period. Also, if a company fails to repay deposits under Section 73 or 74, they are completely barred from declaring an equity dividend while that default continues. Now, how do you actually pay it? The modes are very specific: cash, check, dividend warrant, or electronic transfer. Payment in kind is entirely prohibited. Just think about it in the real world. Reliance cannot hand you Geo-SIM cards or free inventory as a dividend. As awesome as free data sounds, the law says it absolutely must be monetary. And it's only payable to the registered shareholder, their specific order, or their banker.
Next up, Section 3, unpaid dividends, and the IEPF, covering Sections 124 and 125. Okay, these sections deal with the absolute most critical timelines for your exams. Here is your ultimate memory trick for the exam hall. 3797. Seriously, say it with me right now.
3797. First, the company gets 30 days from the declaration date to actually pay the dividend. If a shareholder doesn't claim it or the company just can't pay it for some reason, the company then has exactly 7 days to transfer that unpaid amount to a special unpaid dividend account in a scheduled bank. Then, within 90 days of that transfer, they have to prepare a detailed statement of who owns this money and publish it on their website. Finally, if that money just sits in the account unclaimed for 7 consecutive years, boom, both the dividend amount and the underlying shares are transferred to the government's Investor Education and Protection Fund, the IEPF.
Now, think about what happens if a company breaks this chain. If they miss that 7-day transfer window to the unpaid dividend account, they don't just get a warning. Oh no, they have to pay a hefty 12% per annum interest from the date of the default, and that interest, it goes straight to the benefit of the unpaid shareholders.
So what exactly is going into this IEPF? Well, it's not just unpaid dividends. Practically any corporate payout that goes unclaimed for 7 years gets swept into this fund. We're talking matured deposits, matured debentures, application money due for refund, and the redemption amounts of preference shares. All of it hits the IEPF after 7 years, and even includes the sale proceeds of fractional shares from bonuses or mergers, plus any government grants. And here's the kicker. If a shareholder suddenly wakes up after, say, 8 years and wants their dividend, they can't ask the company anymore. They have to apply directly to the IEPF authority with all the prescribed documentation. It's a whole process.
Moving right along to Section 4, shares in abeyance under Section 126.
This is a small but heavily tested concept. Picture this real-world scenario. You buy some shares of Tata Motors from a friend. You do everything right and submit the transfer instrument to the company. But the company hasn't formally registered you as the new owner yet. Right in that awkward gap, the company declares a dividend. So, who gets the money? Well, Section 126 says the company has to park that dividend in the unpaid dividend account. Furthermore, any offer of rights shares or issue of fully paid-up bonus shares has to be kept in abeyance, which basically just means kept on hold until your transfer is officially registered. Actually, there is one exception. If the registered holder gives explicit written authorization to pay the dividend directly to the transferee, then they can do that. Otherwise, it all goes on hold.
And finally, Section 5, the penalties for non-payment under Section 127.
All right, we've reached the climax. These are the severe penalties for failing to pay a declared dividend within that initial 30-day window. You need to pay super close attention to this penalty split because students make a massive mistake here every single attempt. For the company itself, the punishment is paying simple interest at a massive 18% per annum during the default period. The company obviously doesn't go to jail, but the director, the one who is knowingly a party to the default, they face real imprisonment of up to 2 years and a minimum fine of 1,000 rupees per day for every single day that the default continues. 18% interest for the company, jail time, and daily fines for the director. Do not swap these two in your exam.
Okay, but are there times when a company doesn't pay within 30 days but is still safe from these brutal penalties? Actually, yes. This is a 3-star theory question, the 5 exceptions to Section 127. Let's walk through them. First, operation of law. Imagine a shareholder's bank account is completely frozen by a court order. The company literally can't pay, so they're exempt. Second, the shareholder gave specific payment directions that couldn't be complied with, and the company made sure to communicate this back to them. Third, there's a legitimate legal dispute over who actually owns the shares. Fourth, the company lawfully adjusted the dividend against a debt the shareholder already owed them, like calls and arrears. And fifth, a general catch-all. Any other reason that was simply not the company's fault at all.
We also have a very specific carve-out for Nidhi companies. If a Nidhi company is paying out a tiny dividend, we're talking 100 rupees or less to a member, they don't have to face those scary Section 127 penalties. All they have to do is announce the declaration in a local language newspaper and display it on the company's notice board for at least 3 months. For such small amounts, the law recognizes that the heavy administrative burden shouldn't crush these little mutual benefit funds.
All right, we've covered the declaration, the strict rules of inadequacy, the timelines, shares in abeyance, and those brutal penalties. Now it's time for the one night before exam challenge. Without looking at your notes, can you recall the exact meaning of the 3797 rule? Remember, 30 days to pay, 7 to transfer, 90 to publish, and 7 years to the IEPF. If you've got that locked in, you are totally ready for your exams. But before we wrap up, I want you to think about this. These incredibly strict timelines and jail penalties exist for a reason.
Just ask yourself, how easily could corporate giants manipulate their cash flows if Section 127 didn't hold their directors personally accountable for every single rupee? Something to chew on. Keep revising, stay focused, and I'll catch you in the next explainer.